Jefferson County Court at Law number 2 is now in session. Court is back in session in 3 cases, calls numbers 23CCCR 1232, cause number 333, cause number M333 226, and cause number M333 228. All 3 cases are styled the state of Texas versus Jennifer Michelle Clannon. Ms. Clannon, is that your full name? Ms. Clannon, would you please raise your right hand? Ms. Clannon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Clannon, you may put your hand down. How are you doing, Ms. Clannon? I'm doing fine. Thanks for asking, Ms. Clannon. You're represented in your cases by your attorney, Attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Good morning, Your Honor.
Good morning, Mr. Lawrence. Do you waive a record in Ms. Clannon's cases?
Yes, we can waive a record, Your Honor.
Okay. Ms. Clannon, in cause number M333 226, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. And in this information, it alleges that you, Jennifer Michelle Clannon, on or about August 27 of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Clannon, do you understand what you've been charged with? And to this charge, Ms. Clannon, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest?
Would you please put Class B on there, Your Honor? I had checked.
Oh, yeah, that's what I was looking at. Okay, I could just hand it back to you. Yeah, it's a Class B misdemeanor.
Yes, my mistake, Your Honor.
Now, Ms. Clannon, to the charge of Class B misdemeanor, you're entering a plea of no contest? Is that correct?
Yes, sir.
Now, you're entering a plea of no contest freely and voluntarily?
Yes, sir.
And are you entering a plea because you do not want to fight or contest the charges? Ms. Clannon, I also have before me a document that is titled Misdemeanor Plea Admonishments, which is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Clannon, there are a set of initials, JMC, that are on a line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? You have to speak up.
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document here on paper that is titled Discovery Certification. Do you recognize this document?
Sir.
And is this your signature on the line that's titled Defendant?
Sir.
Now, Ms. Clannon, before you signed and initialed all of these documents that I just showed you, did your attorney, Attorney Jack Lawrence, go over these documents with you?
Yes, sir.
And did you read and understand everything that Mr. Lawrence went over? Ms. Clannon, are you a citizen of the United States?
No.
State. I have before me State's Exhibit Number 1, the misdemeanor plea admonishment, and State's Exhibit Number 2, the probable cause affidavit. State, you like to offer State's Exhibits 1 and 2?
Yes, Your Honor.
Any objections, Mr. Lawrence?
No, Your Honor.
Okay. States will admit State's Exhibits 1 and 2. Court will take judicial notice of State's Exhibit Number 2. Mr. Lawrence, you advise and counsel Ms. Clannon, is there any evidence that she is currently mentally incompetent to stand trial?
Not at all, Your Honor.
And Ms. Clannon, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Clannon, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of no contest, the state is willing to offer 30 days in jail with credit given for 5 days.
Okay,
She's to turn herself in on or before August the 28th at 6 o'clock, by 6 o'clock p.m. The state is also going to dismiss her trespassing charge 23 CCCR 1232, and this will run concurrent with her resisting arrest charge M333072.
Ms. Clannon, the state is offering that you serve 30 days in the Jefferson County Jail. You will be given credit for the 5 days that you've already served in jail.
Yes, sir.
Your 30 days, your jail time will start on August 28th of 2023 at or before 6 p.m. The court cost in this case is $337. Ms. Clannon, will you be able to pay the $337 court cost?
Your Honor, I'm hoping you can.
Hold on, let I answer the question. Ms. Clannon, are you able to pay the $337 court cost?
I will,
You will be able to pay it? No, I mean, okay, you said eventually. I mean, eventually could be 50 years from now, but eventually. So the question now, we just need to know now, are you able to pay it? Either yes or no. If you can pay it, fine. If you can't pay it, fine. Then we can proceed to the next step. You can't, okay. Now, Ms. Clannon, I have before me a document that is titled Jefferson County Affidavit of Indigence. Mr. Lawrence, would you please hand this document to your client?
Mhm. Yes,
Now, that's a Jefferson County Affidavit of Indigence. Now, Ms. Clannon, do you recognize that document?
yes, sir.
Now, on page 2 of that document, there is a signature above the line that is titled Defendant Signature. Is that your signature? Is it on page 2? Okay. Now, Ms. Clannon, is everything in that document still true and correct today?
Yes, sir.
Okay, Ms. Clannon, the court is going to find that you're indigent. Based on the finding of indigency, the court costs in this case will be waived. That simply means you would not have to pay it. Do you understand that?
Yes, sir.
Okay. Now, Ms. Clannon, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
So, Ms. Clannon, you serve 30 days in Jefferson County Jail, you'll be given credit for 5. The jail time is to start on August 28, 2023, at or before 6 p.m. The court has found that you are indigent, and based on that finding of the indigency, the court cost in this case of $337 will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. This case will run concurrent with the companion case, cause number M333228, and the state will be dismissing cause number 23CCCR 1232. Now, Ms. Clannon, we will move on to your next case. Your next case is cause number M333228. And in that case, Ms. Clannon, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jennifer Michelle Clannon, on or about August 27 of 2022, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of evading arrest detention. Ms. Clannon, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Clannon, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Clannon, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, JMC, on a line next to a box that's checked no contendory, which means no contest. Did you place your initials on this document?
Yeah.
On page 3 of this same document, there is a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have before me a document that is titled Discovery Certification. This document is on paper. And Ms. Clannon, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Clannon, before you signed and initialed all of these documents, did your attorney, Mr. Lawrence, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? State, I have before me states exhibits 1 and 2. States 1 is the misdemeanor plea admonishment. States 2 is the probable cause affidavit, which is in the court's file. State, do you like to offer states 1 and 2?
Yes, Your Honor.
Any objections?
No objection.
No objections. States exhibits 1 and 2 are admitted. And Mr. Lawrence, you've advised, well, you've advised and counseled Ms. Clannon in this case as well. Is there any evidence that she's currently mentally incompetent to stand trial?
None,
this case.
none at all, Your Honor.
And Mr. Clannon, your attorney, Mr. Lawrence has advised and counseled you in this case. Are you satisfied with his representation?
Sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Clannon, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of no contest, the state has offered 30 days in Jefferson County Jail with credit for 5 days. She's to turn herself in on August the 28th, no later than 6 p.m. We're also going to dismiss the criminal trespass 23CCCR 1232. And this shall run concurrent with her theft class B M33226.
Yes.
Okay, Ms. Clannon, the state is offering that you serve 30 days in the Jefferson County Jail. However, you will not be required. Well, however, you'll be given credit for the 5 days that you've already served. Your jail time, well, the court cost in this case is going to be waived because the court has found that you were indigent. And based on that finding of indigency, The court costs will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. This case will run concurrent with cause number M333226, and the state will be dismissing cause number 23 CC Ciara 1232. Ms. Clannon, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer, in your case, is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Clannon, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Clannon, you're gonna stand on the X next to your attorney and follow the directions of our clerk. The clerk will give you a copy of your paperwork and the dismissal that I'm signing.
Thank you, Your Honor.
Thank you.
Are these our copies or?
No, that's fine. Thanks. And Mr. Lawrence, I think this is your last case.
Yes,
Yep.
Your Honor.
Okay, you free to go. You have a blessed day, Ms. Clannon. Once you finish up, you'll be free to go and you have a blessed day.
Thank
Thank
you, Your
you.
Honor.
You're welcome.
No, you don't. Yeah, they just confirmed. I'll be sending it. Okay. Okay.
Dwayne Joseph Francis. Would you go get Mr. Francis?
Thank you.
Can you give me a copy of this?
He's found that plea,
I'm with you.
burglary, and he's gonna forfeit the weapon and dismissal of the unlawful care.
This is cause number 23 CC Ciara 0684. And cause number M333818. Both cases are the state of Texas versus Dwayne Joseph Francis or Dwayne Francis. Mr. Francis, your full name Dwayne Joseph Francis? Okay, Junior. Mr. Francis, would you please raise your right hand? Mr. Francis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Francis, you may put your hand down. How are you doing, Mr. Francis? I'm doing fine. Thanks for asking, Mr. Francis. You're represented in your case by your attorney, Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, Judge.
That's good. Mr. Reynolds, do you waive a record in Mr. Francis' case?
So wait, Judge.
Okay. Mr. Francis, I have before me a document that is titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Joseph Francis, on or about September 14th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of burglary of a vehicle.
Yes,
Mr. Francis, do you understand what you've been charged with?
yes.
And to this charge, Mr. Francis, how do you plead? Guilty, not guilty, or no contest? Guilty? Now, you're pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Okay, now, Mr. Francis, I also have before me a document. Now, Mr. Francis, I swore you in?
You did, Judge.
Okay. Now, Mr. Francis, I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes,
And on page 2 of the same document, there's a set of initials DF on the line next to the box that says check guilty. Did you place your initials here?
yes, sir.
On the next page of the same document, there's a signature above the line that is titled defendant signature. Defendant.
Yes, sir.
Is this your signature?
Yes.
On the next document is titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes,
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
yes,
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
yes.
Now, Mr. Francis, I also have before me a document that is titled
Because I was wrong, so
yes, yeah,
I had to change it.
wait up.
You premature, you filled it out for the wrong cause number. I just changed it at the top.
No, it's wrong on here.
That's for the burglary.
I know, the burglary is, the last 4 numbers is 0684. You got 0208.
I have 0208 for the burglary.
I'm looking at the information.
And
Information says 23CCCR 0684.
I don't have that.
That's what I picked up off the document.
And that's on the document
And
too,
it's-
0684.
It's not in Odyssey. It's 0208. So you can put it whatever you see.
Unless he has another case.
This is from 2022, 9/14/2022. Burglary of a vehicle.
I don't know. I'm looking at it. The information
Wow.
says, I don't know where you get that. Hold on a minute. We looking at the same thing. You must be looking, he must have something else. Yeah, he must have something else. He must have another one.
It's 2 cases.
Prosecutor, that's your prosecutor case number. I'm looking at here, it says case cross-reference
You're right.
prosecutor case number. Okay, here you go. Okay, thank you.
Mhm.
Now, Mr. Francis.
Yes.
Let me do this here. All of these numbers. it's like- Okay, now, Mr. Francis, I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Mr. Francis, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you read and understand everything that he went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Francis, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, would you like to offer State's Exhibit number 1 in
Yes, Your
evidence?
Honor.
Any objections?
There are no objections, Judge.
Okay, no objection. State's Exhibit number 1 will be admitted into evidence. Mr. Reynolds, you've advised and counseled Mr. Francis. Is there any evidence that he's currently mentally incompetent to stand trial?
No, sir.
Mr. Francis, your attorney, Mr. Reynolds has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes.
Mr. Francis, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of guilt, state is offered 180 days in jail, probated for 1 year, a $750 bond, 80 hours of community service. Also court costs, dismissal of an unlawful carrying a weapon charge, M33818.
Dismissal. Do we know his court costs? Us. 277.
And just to add on with that dismissal, he'll be forfeiting his weapon.
Okay. Trina, I'm gonna need to see your calculator. Forfeiture the weapon. Okay, thank you. And what was that?
277.
277. And Mr. Reynolds, you was appointed.
I was
You
appointed.
were appointed. Okay, Mr. Francis,
Yes.
the state is offering that you serve 180 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail on this case because you will be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $750 plus court costs of $277. You'll be required to pay a probation fee, $60, a urinalysis fee, and then that's $60 each month.
Yes.
A urinalysis fee of $15 each month, a reimbursement fee of $15. You will also be required to reimburse the Jefferson County Court appointed attorney's fees of $300. Your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $204 a month. Will you be able to pay the $204? You will? Now, the state will be dismissing clause number M333818 for forfeiture of the weapon in that case. And I have before me a document that's titled Motion to Forfeit. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Francis, before you signed and initialed this motion to forfeit, did your attorney go over this document with you?
Yes.
And did you read and understand everything in this document? And is everything in this document true and correct to the best of your knowledge?
Yes.
And you're asking the court to grant this motion, is that correct? Okay, now, the court is granting the motion to forfeit this weapon to the Beaumont Police Department. Now, Mr. Francis, you will also be required to adhere to the other standard terms and conditions of this probation. Mr. Francis, do you understand the state's offer?
Yes.
And do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Mr. Francis, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Francis, you're going to stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. And Mr. Reynolds, I think you have one more.
Trevor Bird, he's outside.
Trevor Burge, Miss Trevor Burge. This is cause number M333842, case of style of state of Texas versus Trevor Burge. Mr. Burge, is that your full name?
Yes, sir.
How you doing, Mr. Burge?
I'm all right.
That's good, Mr. Burge. You're represented in your case by your attorney Nathan Reynolds, Attorney Reynolds. What is your announcement?
Judge,
In Mr. Burge's case?
Mr. Bird has a case pending in the criminal district court, and we've worked out an agreement on that one. I've asked the coordinator to put us on the first available docket for him to dispose of that. He was going to do that this afternoon, and I'd asked that this court place is
Misdemeanor on the
case
same date?
Yes, sir.
Okay,
As of yesterday, we didn't have a date in there.
But I just talked to her this morning, so she was gonna do it when they changed the job.
okay. So we'll have our coordinator to check. And then when she finds a date, she's gonna place it on the same date.
That'd be great, Judge.
Okay, so y'all free to go?
Thank you, Judge.
All right, you're free to go, Mr. Burrs, and you have a blessed day, and Mr. Reynolds, you have a blessed day as well.
Thank you so much.
You're welcome. Thank you.
Good shot.
Mr. Mayfield, please come forward. Hey, your full name is Fabian Dwayne Mayfield? How you doing, Mr. Mayfield? That's good, Mr. Mayfield. You're representing your case by Attorney Giles Cole. Attorney Cole, how are you doing?
Great job.
Mr. Cole, what's your announcement in Mr. Mayfield's case?
Yeah, as I discussed with DA Porter, he has some other issues in another court,
Okay,
and wouldn't for that M2RP to be filed, and else should you reset this, so.
okay. Give us a reset date.
October 13th.
Okay, this case will be reset to October 13th, 2023. Mr. Mayfield, once you get your reset, you're free to go and you have a blessed day.
Yes.
And Mr. Cole, you'll be free to go as well and you have a blessed day. Okay. And we have Mr. Burbank, Ms. Carla Nunez Zavala. She here? Okay. This is cause number M 333-354, case of Solid State of Texas versus Carla Nunez Zavala. Ms. Zavala, is that your full name?
Yes, sir.
How you doing, Ms. Zavala? I'm doing fine. Thanks for asking, Ms. Zavala. You representing the case by your attorney, Tom Burbank. Attorney Burbank, how are you doing? That's good. Mr. Burbank, what is your announcement in Ms. Zavala's case?
I believe that she was set to file our non-pretrial release, but she had a death in the family.
Oh, okay.
And so
Sorry to hear
she
that.
asked that it be reset to the next time for pretrial. She has been accepted.
October.
She just could not make the date.
I think the next time is gonna be October for pretrial.
Yes.
So we're gonna set it in the second week of October. Ms. Zavala,
You could set it after whatever the date. is.
yeah, it'll be the first week. They usually do it's usually the first Thursday of the month. And so we're gonna set this in the second week of October, which shouldn't conflict with that date. Okay, should come after that date, but Ms. Zavala, you and your family have my condolences. And your case is going to be reset. What is that reset date? I think he was doing October 16th.
Pretrial, yes, sir.
Okay, we reset it to October 16th, 2023. Your attorney's gonna get your reset. Once you get your reset, you're free to go and you have a blessed day. And this is Mr. And this is, next case is cause number M 333-218, case of Solid State of Texas versus Paul Thompson III. Mr. Thompson is appearing via Zoom. Mr. Thompson, how are you doing?
I'm doing well, and yourself?
Doing fine. Now, Mr. Thompson, you're represented in your case by your attorney, Thomas Burbank. Mr. Burbank, what is your announcement in Mr. Thompson's case?
We're still in discovery, Judge. We asked for one reset before we announce.
Okay. Give us a reset date.
October 13th.
Okay, this case will be reset to October 13, 2023
Uh,
to allow,
I believe he is still out of state. And so I would also request on that date, October 13th, that because it's just an announcement, it cannot confirm. I mean, can do it by some.
okay, yeah, I mean, he can do that. Now, this case is gonna be reset to October 13, 2023 for announcement to give your attorney an opportunity to complete the discovery in this case. Mr. Thompson, thanks for being patient with us. You're free to go.
Yes, sir, no problem. Thank you.
Okay. Okay, you're free to go, Mr. Thompson, and you have a blessed day.
Yeah, I do the same. Thank you.
All right, you're welcome. Mr. Burbank, you're gonna get it reset. And now, next case, you need to pull out Willie Kane. He's in,
In custody?
yeah, you probably need to,
That's the reason.
yeah, you probably need to talk to him.
We have an offer.
Mr. Butler, your court time started, court today started at 9 a.m. Okay, at 9 a.m., your attorney, Mr. Todd LeBlanc was here. Okay,
I've been told y'all that.
you had an attorney, and your attorney, the last time you was here, you asked him to file a motion to withdraw. Okay,
I was good or not.
you wasn't in this courtroom. Well, the bailiff is right there. She went out and called your name a couple of times.
Yeah, I was out there though. I probably
Did you
had.
hear me?
I was out there.
Did you hear me?
No, ma'am.
You wasn't there.
She called your name several times.
I was there. You know, really was out there. I was here at night. Sitting on this. That's why I came in, because I ain't hear my name. I came in to look to see what was going on.
Okay.
You know, out there.
Hey, there's no time to
I know, but I'm telling you.
debate. Let me now. You saying a couple of things that don't.
I was there and I was.
I understand that, but I was going back to the fact that you said that you didn't have no attorney, and we appointed you an attorney. Okay.
On a minute, man.
Well, you had Mr. Todd LeBlanc representing you. Hold on a minute.
I told you I would have represented my.
Hold on. Wait up. You said you never had an attorney. We keep paperwork on everything that we do here. Okay. In fact, let's see. Butler. Okay. Let's see. Judge's explanation. On November 1st of 2022, I have a document here that's titled Judge's Explanation of Rights to Defendants Without an Attorney. There's a signature, it says Elliot Butler. EB, they have some initials on the line saying, I want to apply for court-appointed counsel. Okay, that was November 1st, 2022. Then on that same day, you were appointed Todd LeBlanc, November 1st of 2022. The appointment, because this was an arraignment, was given to you by our court coordinator, and you were told to contact Mr. LeBlanc, and Mr. LeBlanc was given information to contact you. Okay, and it has Mr. LeBlanc's address on here, has his phone number and fax number. All right. So apparently when you appeared in court, you asked that Mr. LeBlanc withdraw from your case. Mr. LeBlanc filed a motion to withdraw. Did you receive a copy of that motion to withdraw?
I think I have a copy of it.
Okay. Yeah, could you print him off a copy of this motion to withdraw?
Point myself because he was not talking to me.
Yeah.
He didn't even know nothing about.
Okay, let me just say, okay, you just said you didn't have no lawyer. How you gonna be talking to him? And you said you wanted to represent yourself.
When I had him there, I even came up here the day of court and I talked to you about that in front of him. I said he was not talking to me. He was not, I'm trying to call him. I had to go through constantly blow his phone up to get him to talk to me about my case or whatever. Then when I come over to talk to him about my case, he know nothing about the case. He thinking I was somebody else.
Okay.
That's the reason why I asked to miss him. I could have just appointed myself. That's what I asked him.
Okay. He has, we're gonna give you a copy of that motion that he has filed. And please get that motion from our court coordinator. You can have a seat at the table where, so you can sit down and read it. And then when you finish, we're gonna ask that you come back up. Okay. No, you gotta stand in front of the,
Is that-
only the attorneys stand on the side, defendants stand in the middle. Okay, now, Mr. Kramer, this is cause number M 333-072, case of style, the state of Texas versus Charles Jason Kramer. Mr. Kramer, is that your full name?
Yes, sir.
How you doing, Mr. Kramer?
Pretty good. How are you?
I'm doing fine. Thanks for asking. Mr. Kramer, you represent, well, you are pro se, which means you're representing yourself. Is that correct?
Yes, sir.
Okay, because I have a copy of the waiver of counsel in the court's file, and also have judge's explanation that is signed and initialed by you, informing the court that you wanted to waive your right to an attorney to represent yourself. Is that correct?
Yes, sir.
All right. Now, I also have before me Assistant District Attorney Erica Porter. And now your case was set for an announcement today. And I see here that prior to this court date, you filed a motion, and the motion is the motion is titled motion to dismiss.
Yes, sir.
Is that correct? So what we need to do pursuant to Article 28.01 of Texas Code of Criminal Procedure, we have to set this for a pretrial hearing. Okay, so you have your motion. Excuse me, so the clerk can hear your motion. Okay,
Yes, sir.
now give us a date, give us a court date for his pretrial hearing.
Yeah. Like I had my discovery request and I got to go view the evidence. Can I actually have it to like physical copies to where I can prepare better for the pretrial hearing?
Okay. If you read Article 39.14, if I'm not mistaken. And it's 39 point, I think it's 30, let me just make sure, I think I'm right. 39. Yeah, 39.14 of the Texas Code of Criminal Procedure, they're not allowed to give you copies. They can give you access to the discovery.
Yes, sir. It's just, I should have took better notes when I was there.
Okay,
But it's kind of hard to go off of.
okay, you might want to see if they can allow you to review it again. Okay,
I have to,
you have set an appointment with the district attorney's office. Okay,
yes, sir. Thank you.
now, what, we need a court.
September 25th. We do have a court report.
Okay, we're gonna reset it for September 25th. Now, what day of the week is that? Okay. Okay, we'll reset it for September 25th of 2023. And that's gonna be your pretrial. Okay, now your case has been reset to September 25th for pretrial conference. Our court coordinator is going to give you a reset. Once you get the reset from the court coordinator, you'll be free to go. You have a blessed day. Thanks for being patient with us.
All right. Thank you.
You're welcome. Court is back in session and calls number M 332-706, case of South State of Texas versus Elliot Trayvon Butler. Mr. Butler, is that your full name? Okay, now, Mr. Butler, have you had an opportunity to review the motion to withdraw that was filed by your attorney Todd LeBlanc?
Yes, sir.
Do you have any objections to Mr. LeBlanc withdrawing in your case? Okay, the court is going to grant the motion that was filed by Attorney Todd LeBlanc. Let's see, this is. Attorney LeBlanc is officially withdrawn from the case. Okay. Now, Mr. Butler, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you can hire an attorney. Do you understand that option? You have to speak up.
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. On number three, you may waive your right to an attorney. That is, you may give up your right to have an attorney to represent you, and you may represent yourself. Do you understand that?
Yes, sir.
Now, what do you want to do?
Represent myself.
Okay, now, Mr. Butler, just have a seat at that table. We need to give you some paperwork. You have to sign some paperwork. One of the documents that you have to sign is right here is a waiver of counsel for purposes of entering a guilty plea or proceeding the trial. And could you just have a seat, the bailiff, and then we got to give him a judge's explanation as well. Yeah, he's gonna sit at the table,
Okay.
so he doesn't need a clipboard. Do we have a judge's explanation? Jefferson County Code at Law number 2 is back in session. Court is in session in cause number M332706, cases style State of Texas versus Elliott Travon Butler. Mr. Butler, would you please raise your right hand? Mr. Butler, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Butler, you may put your hand down. Again, Mr. Butler, how are you doing? That's good. Now, Mr. Butler, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line stating that you would like to waive your right to an attorney and represent yourself? Also, I have another document here that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Butler, before you signed and initialed these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Butler, also pursuant to Ferretta versus California, 422 US 806, I must ask you some questions. Have you ever studied law?
A little bit, not too much.
You haven't, you said not too much.
I studied law a little bit.
You studied law a little bit, okay. Have you ever represented yourself in a criminal action? No. You haven't, okay. Do you understand the charges against you?
Not really.
Okay. Are you familiar with the exact legal elements of the charge against you? Now, do you realize that if you are found guilty, let's see. Wait for your information. Now, you realize that if you are found guilty, because this is a Class A misdemeanor, the range of punishment is, well, you could be sentenced to confinement in the county jail for up to a year. You understand that? We run fine up to $4,000.
No.
You understand that? Or you could be given both such fine and confinement.
Yes, sir.
Okay. Now, do you realize that if you represent yourself, you are on your own? And in essence, as a judge, I cannot tell you how you should try your case. You understand that?
Yes, sir.
Actually, I can't give you any advice on how to try your case. Do you understand that?
Yes, sir.
And I can't help you in any way. Do you understand that?
Yes, sir.
Are you familiar with the Texas rules of evidence and Texas case law? Okay. Do you realize that the Texas rules of evidence and Texas case law govern the evidence, how or what evidence is admitted into your case? You understand that?
Yes, sir.
Now, if you represent yourself, you must abide by those rules. Do you understand that? The rules of evidence that I just mentioned and the Texas and any other rules of, required under Texas case law.
What is it?
I can't tell you that, but I'm just saying that there are rules that apply in cases, and you must abide by those rules. Okay. For example, do you know how to conduct a voir dire examination? Okay, that's how to pick a jury. Do you know what are the grounds for excusing a juror for cause? Okay. Do you know what is hearsay?
Yes, sir.
Okay. And do you know what are some of the exceptions to hearsay? And what is proper impeachment of a witness? Do you know that? How to impeach a witness? Do you know when character evidence is allowed in a case?
See, no character.
Do you know when character evidence is allowed in a case?
No, sir.
Do you know when and how to make a proper objection?
Yeah.
Oh, you do? Okay. Do you know when and how to move for a directed verdict?
No.
Okay. Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for mistrial? You do? Okay. Well, since you do, what else? Give me an example of a proper ground for mistrial.
Reschedule the case.
Well, not rescheduling the case. You're talking about continuous. That's not the same. Okay. Are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court?
Say it again.
Are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court? Okay. Do you know how to request and object to jury instructions? Okay. Are you familiar with the Texas rules of criminal procedure? Do you realize that those rules govern the way in which a criminal action is tried in court?
You see, those wait. Cool.
Yes. You don't know that. Okay. Now, I must advise you that in my opinion, you would be far better defended by a trained lawyer than you can be by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You are not familiar with the court procedure. You are not familiar with the rules of evidence. I would suggest strongly, or I would strongly urge that you try not to represent yourself.
I would represent myself, Judge.
You
I
rather,
didn't do anything. I didn't do anything.
so you still want to represent yourself?
Yes, sir. I got evidence, proof. I didn't do none of whatever's going on, trying to get this case over with, do what I need to do with my child, man.
Okay,
I don't know why I'm being.
okay. Well, now, there's a couple of things you said, man and stuff. Those terms are not used. You said judge, okay? Said, now in light of the penalty that you might suffer if you are found guilty, in light of all the difficulties of representing yourself, it is still your desire to represent yourself and to give up your right to be represented by an attorney. Is that correct?
Right.
Okay. So is your decision entirely voluntarily on your part?
Yes, sir.
Okay. So I find the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself. And so at this time, your case is going to be reset for an announcement. And what the announcement is, that's the day that you're going to come back to court to announce what you're going to do in this case. And in between that date and today, you'll have an opportunity to go to the district attorney's office, set an appointment to go to the district attorney's office so that you can have access to the evidence that they'll be using against you in your case so that you can prepare for trial.
There's no evidence. I've been, I had
Well-
no evidence, but
Okay, Mr. Butler. You said a couple of things that totally doesn't make sense. First of all, you say they said that there is no evidence. Who are they?
my lawyer that I had, that y'all pointed to me.
Okay, the lawyer that you said you did not have.
I had a lawyer, I had to go through.
And you said you never
I had
talked
go
to
through
him.
Excessive things to talk to him. I had to go through excessive measures to get in touch with him. If I have to, I told you when I came up there.
You said you didn't do that. You said you couldn't, you kept making repeated phone calls and stuff, and you never was able to contact him until he came to court that day.
Right, he didn't, I told you up here that day, El Court, when he was up here in your face, Judge, he was here. I also told him in his face as well. He's telling me I had. first he
Well, you
told
don't,
me-
let me
first he
do this
told
here. Let me do this here. You have a right against self-incrimination. Anything that you say can and will be used against you in the court of law. And the reason why I did that is because if you want to go into the facts of the case,
I'm not
don't
going
do
into
that.
facts of the case. I'm
Don't
talking
do that.
about the lawyer who I
Okay.
discussed with him.
Okay,
I'm not going into no facts of the case. I'm talking about what I've discussed with him. I have talked to him. And,
okay. No, whatever you said to your attorney, we call that what is called attorney-client privilege. It's privileged information, confidential information,
right, I'm
cannot
not
be
getting too much-
disclosed unless you voluntarily disclose it.
I'm not trying to get into too much detail. I'm just telling you what we discussed.
Okay, but let me do this here.
That I talked to him and he told me about the evidence, and then I asked him about the evidence, he told me there was no evidence.
Okay, so he told you there was no evidence.
Yes, sir. Cause he told me it was, and he looked at it, he told me he had the wrong, he looked, like I told you, he had my case wrong, he had me for somebody else.
Okay, so he was saying that he mixed your case up with another case.
Yeah, as if I had.
Now, think about what you just said. Just think about it. No, listen, I'm getting ready to make a statement.
All right,
If he said he had the wrong case, he was telling you that they didn't have no evidence in that case. They may have evidence in your case. And what I'm saying is you'll have an opportunity to see it for yourself.
yeah, I would like to see it, and I'll.
Okay, good. Good. So you'll have an opportunity to see that evidence for yourself.
Right.
And then when you come back to court, then we can set your case for trial. Okay, unless you want to set it for trial now.
I thought this was my trial date here, sir.
No.
I'm coming from
No,
Louisiana.
listen. Okay, let's do this here. Let's give him a trial date. Okay, we're gonna give you a trial date. And in the meantime, you need to set up an appointment with the district attorney's office. We have a prosecutor here in court. Okay, set up an appointment so that you can review the evidence before your trial. Okay, now, of the abundance.
I'm not a minute.
No, hold on. Let me do this here. Yeah. If we're gonna set it for trial, of the abundance of caution, I'll appoint a standby attorney. What the standby attorney will do is, if you need any help or legal, now they can't help you to try your case, but you could get advice from them. Okay? And that standby attorney is going to be Miss Jennifer DeLodge or Jennifer Mattingly DeLodge. Is that correct? DeLodge? DeLodge. Okay. So she's going to be your standby attorney. Okay. Now let me, and that's going to be on that paperwork that we give you. And we're going to reset it for, no, give him a little bit more time. We're going to give you a little bit more time because you have to do the appointment and get the information from the DA's office. Okay. Okay. So give him a little bit more time. Okay. Is November a good time for you? Because I know you say you live in another state, you live in Louisiana.
Try to come back and forth, y'all can reschedule my case.
Okay, we're trying to, if you listen to what I'm saying, we're trying to make this convenient with your schedule.
I understand that y'all been trying to do that, sir. And I've been telling y'all my schedule, and it's hard for me to come out here sometimes.
I'm asking your schedule right now.
I'm trying to tell you. I don't know if I'm gonna be able to make it out here in November. Maybe I might have to do a video call this time.
No, well, if you can't, listen what I'm saying. If you said you wanted your case set for trial, if you wanted your case set for trial.
What's the date? I was told this was my last day.
No, nobody told you you had a trial date.
So this was my trial date.
Who told you that?
When you told me.
I told you that?
It was either used or.
No, we didn't tell you that.
But today, I was told it's my.
Oh, I didn't, hold on, earlier I told you, what did I tell you? We keep paperwork on everything that we do here. There is no paperwork that says your case is set for trial, and there is no record
Y'all didn't even
of
know.
me telling you that your case is set for trial. This case was set because you said you wanted your attorney to withdraw. You didn't want him to represent you. And so he had to file a motion to
And I
withdraw.
represent myself that day. And I'm.
You couldn't represent yourself that day. There are things that has to be done.
Couldn't do it that day, but I had to represent myself.
I understand. Okay, that's past tense. You are getting what you wanted today.
All right.
Okay, we have to go through these procedures. Okay, you say you don't understand the Texas Code of Criminal Procedure. There are procedures that we have to go through. There are steps by law that we have to go through. And that's what we just did. Okay, we couldn't do it then because your attorney did not have a motion on record to withdraw from your case. He had to file the motion, that motion was filed, and we heard it today. And so now we'll go on to the next step. The next step is you representing yourself, and after that, you can either set your case for an announcement. Now, you say you couldn't be here.
I might not better be here.
No, listen. If you set your case for an announcement, you could appear by Zoom. If you set your case for trial, you need to be in person to try your case. You understand? Okay. So we're going to set your case for an announcement. Okay. She's going to give you the Zoom number so that you can appear by Zoom on that day. All right. So we're going to reset it for an announcement.
October 13th.
Now, Miss Porter, or Mrs. Porter, how long we need to schedule out so you can have an opportunity to set up a permit to have access to the discovery?
I would say at least 30 days.
Oh, okay, October will be fine then. Okay. Give us what's that October date?
13th.
Okay, your case is going to be reset to October 13th. She's going to give you a Zoom number. You can appear by Zoom. Before that date, you can have an opportunity to talk to the prosecutor to look at the evidence. And then on that date, October the 13th, when you appear, you can tell the court, yeah, and we can set your trial date. All right. So just stand in front of the court coordinator. She's going to reset your case. Once your case is reset, you're free to go. You can talk to the prosecutor and they can tell you how to set up the appointment so that you can have access to the discovery. All right.
Can you sign that order?
The order is right here. Yes. This is okay, Mr. Kane. You ready on Mr. Kane?
Yeah.
Jefferson County Court at Law number 2 is back in session. The court is in session. And cause number 23CCCR 0766. The case is styled the state of Texas versus Willie Kane. Mr. Kane, is that your full name?
Yes, sir.
Mr. Kane, would you please raise your right hand? Mr. Kane, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Kane, you may put your hand down. How are you doing, Mr. Kane? That's good. Mr. Kane, you're here represented by your attorney Thomas Burbank. Attorney Burbank, how are you doing? That's good. Mr. Burbank, do you waive a record in Mr. Kane's case? Mr. Kane, I have before me a document that is titled misdemeanor plea, that's titled information sheet. On this information sheet, it alleges that you, Willie Kane, on or about January 1st of 2023, while you were in Jefferson County, Texas, that you was charged with possession of dangerous drug. Mr. Kane, do you understand what you've been charged with?
So,
And to this charge, Mr. Kane, how do you plead? Guilty, not guilty, no contest? Now, you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
yes, sir.
On page 2 of this same document, there's 2 sets of initials. One set of initials is your attorney initials, and the next set of initials, WC, or your initials. Did you place your initials next to your attorney on the line that's next to a box that says no contendory, which means no contest? All right. On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document is titled trial court certification of defendant's right of appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document before me that is titled discovery certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Mr. Kane, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge? Mr. Kane, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit number 2, the probable cause affidavit, which is in the court's file. State, would you like to offer States 1 and 2?
Yes, Your Honor.
Any objections?
No objections.
No objection. States Exhibits 1 and 2 are admitted. Mr. Burbank, you advised in counsel, Mr. Kane, is there any evidence that he is currently mentally incompetent to stand trial?
No,
And Mr. Kane, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Sir.
Mr. Kane, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of guilt or no contest, the state has offered 20 days in Jefferson County Jail, given credit for 18 days for court costs.
Okay, Mr. Kane, the state is offering that you serve 20 days in the Jefferson County Jail. However, you would not be required to serve any time. Well, you will be given credit for the 18 days that you've already served in this case. The court cost in this case is $337. Will you be able to pay the $337 court cost? Okay, Mr. Burbank, could you hand that to your client? Now, Mr. Kane, your attorney has handed you a document that's turned affidavit of indigence. Do you recognize that document? Now, on page 2 of that same document, there's a signature above. There's a signature that says defendant's signature. Is that your signature? Okay, now, Mr. Kane, is everything in this document still true and correct today?
Yes, sir.
Mr. Kane, the court is going to find that you are indigent based on this finding of indigency. The court cause in this case is going to be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. What that simply means, Mr. Kane, is that you would not be required to pay the court cost of $337. Now, Mr. Kane, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
So,
And do you accept the state's offer?
yes, sir.
Mr. Kane, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Kane, this will conclude your case. You're going to stand on the X next to your attorney, follow the directions of our clerk. Once you finish following the directions of the clerk, you can follow the bailiff, and you have a blessed day, Mr. Kane. And Mr. Burbank, you have a blessed day as well. Yes, you may be excused. This is cause number M329630, case of Style State of Texas versus David Kenneth Tan. Do we have bond conditions in this case? Mr. Tan, your full name is David Kenneth Tan.
Yes, sir.
How you doing, Mr. Tan?
Yes, sir.
That's good. Mr. Tan, you're representing your case by your attorney, Attorney Marcus Wilkerson. Attorney Wilkerson, how are you doing?
I'm doing well, Judge, and you do bond conditions.
Okay, that's what I was looking for. Okay,
Your Honor, we are requesting a 30-day reset. We've
Okay.
spoken with the state's attorney,
Okay.
and we're gonna look into a little bit more, look at the case a little bit more and see where we are in 30 days.
okay. Give us a reset date. Okay, this case is gonna be reset to October 13th, Mr. Tan. Your attorney's gonna get a copy of your reset. Once you get a copy of your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Wilkerson, you'll be free to go as well and you have a blessed day.
Judge,
You're welcome. Let's see. Hold on a minute. Oh,
Your Honor, may we go back on the record?
Mr. Tan. Okay, we'll move back on the record and cause number M329630, case of Style of State of Texas versus David Kenneth Tan. Okay, Mr. Wilkerson.
Your Honor, one of the bond conditions that was ordered was that my client have an ankle monitor. We would request respectfully that that device be removed.
Okay,
It's costing my client $300 a month, and
what we need to do is, you need to
file.
file a motion and then we set it for hearing.
Yes,
Okay.
Your Honor. I'll file that motion prior to the October
That's
13th
fine.
date, and perhaps the court can entertain it then if we don't resolve the case.
Okay.
otherwise.
That's fine.
Okay.
Okay,
Thank you, Judge.
you welcome.
May be excused.
Yes, you may be excused. You have a blessed day. Let's see, Miss. Oh, Miss Walker. Mrs. Porter. I think we have one more case still on the docket. Yes, is it Roderick Wise Warren?
Oh. He was here, with
Yes,
his attorney.
that was Jahoma.
Yeah.
Did I sign it?
You signed it, yes.
Okay,
Yeah.
okay, so we don't have any.
You didn't wait for it.
Okay,
I seen them, I know. Did you want this one for?
the commitment, yeah. Okay, well, this will conclude the calling of the court's announcement docket on August 18, 2023, in County Court at Law Number 2, Judge Terrence L. Holmes presiding. Everyone have a blessed weekend.
I think